Hello, and welcome to today's California School Boards Association webinar. AB 1078 is more than meets the eye. What governing boards need to know. As the title suggests, there's a lot to learn about this new legislation and what it means for school boards, administrators, teachers and staff, and the students and families you serve. In today's presentation, CSBA's legislative advocates, legal team, and policy experts will walk you down the winding road that led to AB 1078's passage and signature by the governor on Monday, September 25th. We will explore pre-existing law related to curriculum and instructional materials adoption, identify what remains the same and what's different under AB 1078, and what new obligations the changes create for local school boards and administrators, as well as county superintendents. We'll also touch on developments that prompted AB 1078 and review the bill's legislative history, with particular attention paid to negotiations with the state, where CSBA advocated for local control and obtained some key amendments to make the bill more palatable than its original version. Then we'll preview upcoming sample policy releases that will help governance teams adapt to and comply with AB 1078 before concluding with a question and answer session at the end of the webinar. And we do ask that you place your questions in the question and answer section of the tool, not in the chat section. Now, with no further ado, I will introduce my CSBA colleagues who will guide you on today's legal, legislative, and governance journey through the inner workings of AB 1078. I am Troy Flint, Chief Information or Communications Officer with the California School Boards Association. With me today, we have Chris Reef, our Legislative Director, Carlos Machado, our Legislative Advocate who worked this bill, AB 1078, Kristen Lindgren, our Deputy General Counsel, and last but not least, Joshua Daniels, our Chief of Policy and Governance Technology Services. I will now hand it over to Chris.
Thanks, Troy. Appreciate it. So welcome, everybody. We thought what would be helpful to start off this webinar is a quick primer on what the education code says in regards to what is considered the sufficiency of instructional materials. So we have a few slides here. We thought it'd be helpful to kind of level set a little bit because that's going to be a main theme throughout the webinar, especially as it relates to the bill and the amendments and what was the main focus of the policy related to AB 1078. So starting with the primary code section in the education code 60010 subdivision H, this basically lays out what is the purpose of insufficiency of instructional materials, and that the instructional materials are really meant to be obviously a learning resource, right? Really to help provide and help students to be able to achieve their academic outcomes. It also can mean that instructional materials include printed and non-printed materials, and there also is a requirement that the State Board of Education adopt K-8 instructional materials, but they are not required by the state constitution for adopting instructional materials in grades 9 through 12. And so I'm going to kick it over here to my colleague Carlos, who kind of go a little bit more into the depth in terms of the sufficiency statutes.
Thanks, Chris. Right now, current law requires LEAs to annually determine if publicly adopted resolution to indicate whether each pupil has sufficient textbooks to use in the classroom and to take home. And it's important to note this piece you'll see a through line through the bill as it becomes enacted, that instructional materials under existing law must be aligned to the current state content standards adopted by the state board in math, science, history, social science, and the English language arts. With respect to the resolution, current law states that before the end of the 8th week from the day that the district provides instruction to pupils, that a governing board must adopt the resolution and indicate its determination whether there are sufficient textbooks, and if that determination results in a finding that there aren't sufficient textbooks, then that resolution must include additional information about that insufficiency. And then we also wanted to highlight too that LEAs, in terms of providing textbooks and instructional materials, they can use LCFF funding, and then also Prop 20 lottery funds for the purchase of textbooks. Next slide. Thank you. The other thing that we wanted to highlight here is that as a condition of receiving state funds, LEAs are required to provide their students with sufficient textbooks and instructional materials. And that current law, that's the one that I referenced earlier with respect to the requirement for districts, the governing boards to pass a resolution, Education Code 60119. In that code section, it states that sufficient textbooks and instructional materials means that each pupil, including English learners, has a standard aligned textbook or instructional materials or both to use in the classroom and to take home. So before we jumped into a discussion on AB 1078, we thought it would be helpful to provide the context of what current law states around these requirements now. And that 1078 overlaps with a lot of these existing requirements, definitions, and provisions. So might want to reference these as we continue our discussion on AB 1078 and the legislative history. Next slide, please.
So we're going to go through the legislative history here from start to finish. I think it's a really good representation of how legislation comes to be in California. This bill really started from a different context and it ended up in a different place than where it started. And so we're going to go through that in terms of how the legislative calendar runs, but really want to emphasize that this is a good example of how legislation changes throughout the year as various issues or intent for the bill changes as do the times, recognizing kind of how the bill reflected a number of different actions that occurred throughout the state.
So on this first slide about AB 1078, so as introduced, the bill was heard in the Assembly Education Committee on April 26th. At that time, there weren't any specific examples in the state where this was an issue. In fact, in support of the bill, the author had cited a report entitled Banned in the USA, the Growing Movement of Censor Books in Schools. And in that report, it found that California was among nearly 20 states with no book bans by schools from the period that the report covered, July 2021 through June 2022. That contrasted to other states where they had the greatest number of bans, Texas, Florida, and Tennessee and Pennsylvania. So in that version of the bill, what we saw was a significant trampling on local control. The initial provision in that bill would have required governing boards to seek approval first from the State Board of Education before it removed any books, publications, or papers from schools and school library without first getting the approval from the state board. And then it also made some other changes to requirements around instructional material adoption and a specific provision about the proportional representation of certain groups in those materials, which would have been hard for governing boards and districts to do. We had concerns about this. Obviously, local governance and local control were major issues around that. and CSBA expressed its sincere opposition to the bill in the committee at that point. And I'll turn it over the next slide to Chris.
Yeah, so as many of you know, CSBA, we have a legislative committee made up of school board members representing districts from across the state. This was a bill that we brought immediately to our legislative committee, and much like what Carlos had reviewed, we presented that at the staff level, and the committee immediately took an opposed position. In response to that opposed position, CSBA government relations went right to work. We held a number of advocacy meetings, lobbying meetings, if you will, with both the author's office and the Assembly Education Committee. And in response to that lobbying and that our advocacy, and including, I would say also many of our counterparts in the education world, as well as many of you as school board members who had caught this bill had caught your attention, was really resulting in what the committee did, and that was amendments that committee amendments that removed the state board language requiring that they approve all efforts to adjust or remove instructional materials. That was a significant step, and as a result, it allowed CSBA to remove its opposition and go neutral on the bill. I will say, though, we did, although we did remove our opposition, we remained very much astute and kind of paying attention to the bill because of just the nature of the conversation and nature of a little bit of the controversy around the issue on the national level, but also as it was beginning to bubble up here locally. Through the legislative process and after the bill passed the Assembly Education Committee, basically through late May, it passed through the full Assembly. It had gone through its fiscal review through the Appropriations Committee. It went to the full consideration of the Assembly floor. And at this point in time, when the Temecula Valley Unified School Board chose not to ultimately adopt its social studies and instructional materials because of concerns about references to LGBTQ civil rights histories, the bill had already landed in the Senate. And so at that particular point in time, the bill was kind of in a holding pattern, was about to be set for hearing. And in response to the growing attention that was being shown up here in Sacramento to the actions of the Temecula Valley Unified School Board, the governor became very much significantly involved in the bill, and we saw some fairly significant amendments occur in July, or June, I should say. I apologize. And those apologies. And I think this one's yours, Carlos. I apologize.
Yeah, next slide, please. I think we went to, can you go back one slide, please? There we go. Thank you. As Chris was stating, that the governor got very involved here in around June. After the bill was already in the Senate. The bill did take on a sense of urgency there, given what was happening around the state's interest in this issue and also in one of the districts in the state. So one of the major changes that we saw in the bill is that there was an urgency clause added. And what that means is that upon the governor's signature, that the bill would take effect on that day. So, this isn't common for a lot of bills, but when there is a sense that the author and others want, a statutory change to take effect sooner than what would normally take effect, which is on January 1st of the following year, there was definitely a sense of urgency here. So, because of the urgency clause. And the bill, the amendments included some pretty significant additions to the bill from what we saw coming out of the Assembly. They included some prohibitions on governing boards from prohibiting the use of certain textbooks, instructional materials, and curriculum. And those are detailed more in the next slide, please. So At this point, what we saw is that in addition to significant amendments to the bill, Temecula Valley its board had reversed course and actually adopted a social science instructional materials at its school in its district in July, prior to actually any adoption of 1078. But while that was happening, 1078 was amended, and its new provisions made several changes to its requirements around what authority school district governing boards had. One of the provisions that we had significant concerns about was a scarlet letter provision, is that for a district where there was insufficient textbooks and materials, that there would be a requirement that a notice appear on a district's and the county offices of education internet homepage that prominently included the names of individual board members on that school district governing board if it was determined that they weren't providing sufficient textbooks to their students. There was also a requirement that there be a 2/3 vote by the governing board to remove existing textbooks or other instructional materials or curriculum for a reason other than it contained inclusive or diverse perspectives. There were also a provision that duplicated many existing requirements that LEAs provide students inclusive and diverse instructional materials. And another provision that created a situation where a district could face multiple and conflicting decisions related to alleged insufficiencies. And then in terms of state oversight, it authorized the state superintendent to take action in response to a direct complaint, even while the situation is being investigated and addressed at the local level. And lastly, it gave the state superintendent significant authority to level fiscal penalties. As soon as we became aware of the amendments, CSBA immediately re-engaged in our advocacy efforts, and particularly with the legislature and the governor at this point around these June amendments. I'll turn it over to Chris.
Yeah, right away, the bill was amended about 4 or 5 days before the Senate Education Committee heard the bill. The bill was pretty much fast-tracked at a very early part of that process in response to the governor's involvement. And so we acted quickly to raise concerns and reinstituted our oppose position on the bill, raising a number of concerns. A lot of our concerns obviously were centered around preserving local control and preserving the authority of school boards ultimately. In the bill, did pass this in Education Committee, and then it went into what's called the Senate Appropriations Committee. When the bill was in the Senate Appropriations Committee, we saw a number of amendments taken, amendments that actually helped address or responded directly to CSBA's advocacy, removing what we kind of referred to as the scarlet letter provisions, the provisions that Carlos had just overviewed regarding the posting of the names of school board members on the home websites of the school district and the county board, and also deleting the 2/3 school board vote requirement when removing instructional materials. Those were good concessions. Certainly they were a result of collective advocacy by CSBA and others, but ultimately they didn't go far enough. And in that regard, we chose to maintain our opposition to the bill because there still remain two very significant areas where we have serious concerns, and those concerns remain. The two main provisions being direct and unfettered authority for the state superintendent of public instruction to intervene based upon a complaint being filed directly with his or her office. And then also, and we'll go into this a bit later in the webinar, there's an overlapping complaints process that could create conflicts at the governance level. Although we were opposed, of course, the legislature did pass AB 1078 in the last days of this year's legislative session, And as many of you know, the governor signed the bill into law this past, I apologize, Monday, September 25th. And so now we're going to turn it over to our colleague, Kristen Lindgren, who will help go over some of the legal concerns and other areas of area where issues could arise. Apologies.
Hi, everybody. Happy to be with you today. I'm going to do my best to go through where we see some concerns in this bill and give you some practical implications, as well as a rundown of what the bill actually does. We'll do our best to answer questions, but there is some ambiguity in the bill, and we'll point out where we see that and where we think challenges could come. And like I said, we'll do our best to answer questions that you have. So you can go to the next slide, Chris. As Carlos noted, perhaps the most important, the most important piece of this bill is that it's an urgency measure. So the minute it was signed by the governor on Monday, it was in law. So we are under it now and it needs to be implemented. A few other noticeable things that we just wanted to give as a general overview. There are some ambiguities in this bill that we'll point out. Often ambiguity leads to future litigation. When I was in private practice, that meant that I had job security, but litigation is not good for you all. And so it's unfortunate that there weren't some more defined areas, and we'll point out those to you. What this bill intends to do and does do is remove a significant amount of local control. That was a lot of the fight that we had over, I guess fight isn't the right word, but the advocacy push that we did was over maintaining local control as much as possible. This takes your control away and puts it in the hands of county superintendents and the state superintendent in a lot of areas. So we'll go over what that looks like for you. The other thing is that according to the legislative intent section of this bill, which is the new section 202 of the education code, this is really directed at content and ensuring that the FAIR Act is met, and I'll go over the FAIR Act in a minute, and that marginalized groups are represented in curriculum and instructional materials. But it may have the unintended effect of also impacting districts who are not changing or adopting instructional materials to in any way violate the FAIR Act or any other requirements, but just haven't, for whatever reason, been able to timely update their textbooks and instructional materials, because the requirements and the complaint processes all apply regardless of the reason for not having sufficient state standards aligned curriculum. So we are concerned about those potential unintended impacts. Next slide, please. So let's get into the nuts and bolts of this statute. I want to just note that the FAIR Act was enacted in 2012 under SB 48, and it requires, among other things, that the contributions of certain historically marginalized groups are included in curriculum and instructional materials and textbooks in the state. And also prohibits material reflecting adversely on those groups. So we've already had the legislature come and tell districts what they can and can't include as it pertains to those particular groups and their contributions. And just as a note, that's in history and social science curriculum. There's some flexibility in the FAIR Act. It is left up to districts and teachers how they implement those requirements and how they show those groups' contributions, but they must be provided. The 1078 goes farther on this and says that the LEAs are prohibited from refusing to approve or prohibiting the use of instructional material that aligns with the FAIR Act on that basis. So in other words, prohibiting materials that show those contributions of those historically marginalized groups is prohibited under 1078. And further, a violation of this provision constitutes discrimination under the general anti-discrimination provisions of the Education Code. What does that mean? That means that a uniform complaint, which is complaints that individuals can file alleging discrimination in district programs and activities, can be filed against an LEA for failing to meet this requirement. And In addition, uniform complaints typically, with minor exceptions, are handled through the district first. The district gets to investigate, the district gets to make a resolution or determine no resolution is needed. And then the complainant can appeal to CDE with a final complaint going to the state superintendent. When it comes to instructional materials and a failure to comply with the FAIR Act, the uniform complaint can be directly filed with the state superintendent with no opportunity for the district to investigate or issue its own remedies or resolution. So here's point one of removing local control that was previously in existence. And this allows, not quite done with that slide yet. This allows the state superintendent to get involved in those local decisions. Just a couple of other things. The section 243, which is a new section, also broadly defines instructional material and includes everything up to library books or resources and curriculum for classroom instruction. So it will include these complaints that can be filed would include complaints against any of those particular materials. Okay, next slide. Additionally, the Williams Act's complaints are impacted by this statute. So Williams Act complaints can be brought based on failure to have sufficient standards aligned instructional materials and on a couple of other bases that aren't relevant here. Those are typically handled at the local level, but AB 1078 allows the state superintendent to have a Williams complaint filed directly with the state superintendent based on a failure to have sufficient textbooks and instructional materials. And again, that means sufficient state standards aligned textbooks and instructional materials. So go ahead and go to the next slide. We can talk about what that means. So the SSPI can directly intervene in a Williams complaint. So prior to 1078, Williams complaints about instructional materials stopped at the board level. They were to be investigated by either the principal or superintendent, depending on whether they involved just one school or the whole district. If the complainant did not like the resolution, they had the right to quote unquote describe the complaint to the governing board, and that was it. There was no further ability to appeal that. It was dealt with solely at the local level. Now the SSPI can directly intervene, not wait for that investigation, and have a say in whether the materials are sufficient or not as defined in statute. The only requirement for a complaint to go directly to the state superintendent is that the complainant has to identify the basis for skipping the district and include evidence that supports that skipping over the district and going straight to the state superintendent. We don't know what that means. That language is also in the uniform complaint regulations and is also undefined, so no help there. We're not entirely sure what someone would have to demonstrate to meet this requirement to directly file the complaint with the state superintendent. We also don't know what the process would be for them to follow, and the same is true of the uniform complaints for discrimination. Presumably it would be the regulations for our uniform complaints, but we're not sure because the statute does not have that in its plain language. And we'll just note also that the state superintendent doesn't have to inform a complaint, an LEA that the complaint has been filed. So you might not know until you hear from the state superintendent that they're issuing some remedies against you for failing to have sufficient instructional materials. Okay, next slide. So in addition to the obligations and authority of the state superintendent, county superintendents now have additional authority. And we'll talk about how that overlaps a little bit with the state superintendent's authority. So under section 1240 of the education code, county superintendents always had the ability to enforce the course of study and the use of state textbooks and instructional materials. But this has been amended by 1078 to provide some additional obligations on their part. So specifically, if they determine either through an unresolved Williams complaint, a resolution from the school district that they have not adopted sufficient instructional materials. So that's the piece that Carlos and Chris discussed around that every year by the 8th week of school needing to pass that resolution. If that or an audit finding, any of those things come to the county superintendent and the county superintendent determines that a district does not have sufficient instructional materials, they have to take the following actions in those second two bullet points. And that includes if the district does not take advantage of the opportunity to remedy the deficiency, that includes going to CDE and having CDE purchase textbooks and instructional materials for the district. CDE does have to consult with the district before making those purchases, but again, the bill doesn't say what that consultation entails or what rights the district has in that consultation process. And CDE also has to make a public statement on its website that the district failed to have sufficient instructional materials. So we have a little bit of that scarlet letter piece still there. Finally, this is a loan, these purchase of textbooks and instructional materials by CDE. And if the district fails to repay the loan, then that can be deducted from their next principal apportionment. So a little bit of a potential fiscal penalty there if it plays out through all of those steps. Okay, next slide. Because the county superintendent can take these actions on the basis of an unresolved Williams complaint, we also have the county superintendent effectively being able to intervene in a Williams complaint when, again, it was always ended at the local level before. And because they can intervene and the state superintendent can intervene on a Williams complaint, there could be a circumstance where they both intervene, they both have to take action, and they do something different or render different assessments as to whether there are sufficient instructional materials. The statute does not say which takes precedent. It doesn't provide any real acknowledgement of this overlap. It just has them have their separate powers, duties, and obligations. And so this is an area in particular where we think we could see litigation and where there's some ambiguities that we're not sure how will be resolved. And then we go to the next slide and I'll talk a little bit more about how this continues in the fiscal penalty section. So as you've probably heard, and this was a big piece of all of the reporting on the governor's intervention in the Temecula Valley School District. This bill does bring potential fiscal penalties with it, where the state superintendent can issue fiscal penalties for a failure to have sufficient instructional materials. This is in new section 60150 of the Education Code. And that's in an amount equivalent to what the district would have received in 1213 for the instructional materials block grant. But in addition to that fiscal penalty potential, that section in subdivision A also states that the superintendent, if they determine, the state superintendent, if they determine that the instructional materials are not sufficient, has to take all of the same remedial actions as the county superintendent in Education Code 1240. So again, who is doing this? Who gets the ability to take action? Are they both taking action? What if they have different determinations of sufficiency? These are the areas where we're most concerned about ambiguity in this statute. And we also, unlike with the county superintendent statute, don't see any opportunity for the district to remedy the failure to have sufficient instructional materials prior to implementing any of these remedies. So that is a difference. So there may be a situation where they're able to do that with the county superintendent, but they're still facing potential penalties from the state superintendent. And those are contradictory provisions that we don't have clarity on at this point. And because the statute is so new, we don't have any prior litigation or any other place to look. So, we're just kind of going to have to wait and see how this plays out. So that is all of the pieces of the bill. And we're happy to take questions, but I'm going to pass it over to Josh Daniels for the next section.
Thank you, Kristen. I'm going to briefly talk about the implications for our sample policies. Next slide, please. So just a little bit of context and background. So our gamut policy service is an opportunity for our members to review and adopt the sample policies that we put out. There are about 650 sample policies and bylaws, administrative regulations, and exhibits. They are there both for school districts and for counties. As a reminder, these are samples. The intent is for members to look at them, review them, and adjust them to the context in which each district or county is, obviously within compliance with the law, of course. We include notes within each sample that sort of give you the context, sort of where the legal guardrails are, or the policy or the statutory guardrails are. Typically, we release our policy updates every quarter with a special release on as needed basis. Given the attention paid at 1078, we felt that this was an opportunity to do a special release, which will be forthcoming in October. And I'm just going to quickly mention the policies that will be impacted. So next slide, please. So I think I saw in some of the Q&A some questions about this. So we've looked at and are updating a variety of policies, including the ones you see on the screen. I think I saw a question about 61.11 that is not on this list, but it is on the list that we will be updating, and we expect it to come out in October. And you'll see updates both to the sample district policies and the sample county policies. And I will turn it back to Troy.
Thank you. We will now move to the question and answer session. There are a number of good questions already in the chat. And the first question we'd like to address says this: if a district only has adopted materials approved through the SBE process for grades K through 8, does this mean it meets the FAIR Act automatically since they were part of the criteria that the SBE met? So basically, I think what the person is asking is, if the SBE has approved this, are you in the clear, and does that count as a stamp of approval, and you have no further worries if you just adopt what the SBE has already approved?
Troy, I can take this question. So I want to just be clear, we're not curriculum experts here, and the CDE is the best place to go for these kind of questions. We want to make sure that we're giving accurate information. I think that the answer to that question, though, is probably yes. If there are no state adopted materials for grades 9 through 12, so it would only apply through TK through 8. But yes, those should all meet the FAIR Act. Typically, there are other kinds of materials that are used, however, so you just want to make sure that those also meet the FAIR Act, everything that is being utilized by your teachers.
Thank you, Kristen. Does anybody else want to address it? I think that covers the issue pretty nicely. Great, then we'll move on. The next question is a little more philosophical. Someone is asking whether this sets a bad precedence, saying that a future conservative governor might, for example, want to force religious study in all schools. Will this action by the current governor, is it short-sighted? Is it purely political posturing, or is there any merit to his action in your view?
That was one of the main concerns of our opposition, was the law of unintended consequences in this regard. Certainly, the governor was acting from and the legislature was acting from a position of trying to address the circumstances. I think that folks were watching in Temecula, and Temecula obviously ended up reverse course and local control, and that circumstance worked. But of course, the bill continued to move forward. And so this is one of the reasons why we wanted to have this webinar, so that we could be able to point out some of the larger issues that we continue to see in terms of the implementation challenges. And I think that's one of the things that we're going to be paying close attention to in the coming years, because certainly with legislation of this size and scope, there is going to be a need to potentially do follow-up legislation to clean it up potentially. And so we're going to be very much mindful of what are the unintended consequences of the legislation.
Thank you, Chris. Another viewer expresses concern with the use of instructional materials, asking, when a teacher brings their own books into the instructional process with materials not adopted by the board, what is the responsibility of the board in regulating this process? Or in other words, teachers or other people who are outside of what the board is doing, if they do something that does not align with what the board has approved, what sort of exposure is there for governance teams, or what corrective action is expected of them?
So again, these are questions better directed at curriculum and folks, but the FAIR Act does provide some flexibility for teachers to determine how they want to include specific requirements of the FAIR Act into the classroom. So it is less prescriptive around the exact materials that are being used. If a teacher is using materials that are not standards aligned, then that needs to be addressed by the administrator. It's really something that probably is going to stay at that level. It's not I suppose that someone could file a Williams complaint because one teacher in one classroom is using materials that are not standards aligned. And now we have the potential intervention of the state superintendent, whereas that could have been very easily resolved at the local level in the past by the principal. So, there may be some exposure, and it's a reminder to your administrators that they need to be paying attention to ensuring that teachers and their materials are both standards aligned and meeting the FAIR Act. But teachers do have some amount of discretion as to what to use, so long as it's standards aligned, and they do a lot of professional development and other things to make sure that that is the case.
Thank you, Kristen. We have another question about curriculum, specifically Williams complaints. For a new Williams complaint, could this apply to curriculums that aren't recommended by the state? Let's say a district adopted an ELA curriculum that is not adopted or approved by the SBE list of 2015.
Not necessarily. Districts have the ability, even at the elementary level, to adopt their own textbooks and materials. They have to meet certain requirements, and we're just going to keep pounding on this. They all have to be state standards aligned. So, and they have to meet the FAIR Act. So long as they do that, the mere fact that they aren't state adopted materials is not a problem. You have the right under the education code to use your own materials and not the state adopted. And as I noted, for 912, there are no state adopted materials. You have to pick your own. So they just need to meet state standards, and they just need to meet the FAIR Act and any other obligations in the education code for textbooks and materials. But the mere fact of you not using state adopted materials should not trigger a valid Williams complaint. It is only where there's not sufficient materials that are standards aligned.
Okay.
And I say valid because anyone can file a complaint about anything, right?
Sure. But
that's what we're focused on.
The next question is sort of targeted, but I think we could kind of broaden it and generalize it. The viewer wants to know, how do the general requirements on sufficiency pertain to two-way immersion programs or biliteracy programs? And I think the answer is, or the question is, are there any exceptions, or does this new law apply across the board to every aspect of curriculum and instruction?
So the bill is quite broad, and again, it speaks to kind of the law of unintended consequences and the concerns that we were raising throughout the legislative process. I think, and much to what Kristen was saying, is that yes, we're going to have to defer to some of the instructional material and curriculum experts over at the California Department of Education, and a lot of that is a reflection of just how new the law is. Right, it's going to take some time for the state to be able to provide clarity. And potentially, further regulations to be able to come to fruition, to be able to provide greater guidance and parameters, if you will, for how districts will follow this. And also, it remains to be seen how the state superintendent will be responding. But, because of the expansive definition of what is considered instructional materials, this bill could apply to a wide array of materials that are used in both schools, classrooms, and libraries.
Thank you, Chris. Another viewer wants to know if this bill is being challenged on constitutional grounds. Do we have any information along those lines?
I don't know of anything at this time. It's only been a couple of days, so keep an eye out. And if it happens, we'll certainly report on it.
And this next question pertains to how you qualify representation. They want to know, is representation of various groups measured proportionally, or what is the standard for judging that?
So, like I said, the FAIR Act does not have directives of exactly how to ensure that there is inclusion of contributions of various groups. So it is still, that piece of it is still left to local discretion. And there is flexibility around how that's done. It just has to be done. It looks like Carlos has something to add as well.
Yeah, thanks, Kristen. So as I noted earlier, it does appear that the authors worked on this issue and struggled with it. Earlier version of the bill did place a requirement on governing boards to determine that portionality themselves in approving textbooks. That provision was removed from the bill and is no longer in the current version. But I in terms of the current version, I defer to what Kristen said in terms of their alignment with the standards and with the frameworks now.
Thank you both. The next question asks, what about library books that are sexually graphic? Can we follow our own board policy on book complaints?
So I was just presenting down in Lancaster on Tuesday night, and someone asked, or we were talking about, CSBA has a sample policy about complaints about the content of instructional material. So not a Williams complaint, not a uniform complaint, more of just a local best practice of letting people come and describe concerns they have with the content of instructional materials. And what I can say is that it's a good best practice. You want to hear from your community. You want to know what people have concerns about. But in remedying those complaints and trying to resolve them, you want to make sure that you're not violating the law. So if an instructional material, someone doesn't like it because it contains representation of certain groups, but this bill and the FAIR Act require or prohibit you from removing things because of that representation, then you need to be careful that you're not accidentally, in trying to hear out a member of your community and help them and resolve their complaint, that you're not accidentally then violating a law somewhere else. And it is putting you in a position of kind of having to walk a tightrope for sure, and really carefully make those decisions.
Josh, I think you wanted to weigh in.
Yeah, I just wanted to note that there's some language within 1078 that specifically references board action. So either prohibiting the use of or adopting particular textbooks or not doing so on an improper basis. But as Kristen was alluding to, there still is the general non-discrimination language that exists broadly speaking. And that applies to any decision, whether it's made by a review committee, which is what the sample policy Kristen is referencing typically recommends, or the superintendent or principal. And so just as a general rule across anything that a district does, it cannot be discriminatory. So even though this portion of 1078 focuses on board action, the general sort of non-discrimination sort of philosophy underlying it, is present regardless.
Thank you. The next question regards the time period to remedy the insufficiency. The viewer is asking whether the time period to remedy the insufficiency, the second month of school, is the same time period to declare sufficiency by the 8th week of school.
Generally speaking, yes. That it was meant to, generally the intent was to align the two timelines.
Great. We have a question about financial penalties now. Who would pay for such materials? I assume they're referring to repaying the loan if the state has to step in and distribute materials. What if the LEA did not have the money?
It would be, so in the case of this, the county superintendent, oh, go ahead, Carlos.
No, you're probably going to say the same thing.
Go for it.
So yeah, there is a provision in statute that does provide for a loan to the district. So there could be repayment terms as a condition of that loan. So ultimately, though, that that obligation does fall to the district.
Right, and if the repayment is not made timely, we're not sure exactly what that means, but there could be a deduction from your next principal apportionment. And that is in Ed Code section 1240.
The next viewer mentions that when their district adopted a new social studies curriculum, a piece about Harvey Milk was excluded, and they want to know if that is now illegal.
So this is a tough question on different specific pieces of curriculum. I think if you look at the standards, that person is referenced. There are other people referenced. I think that there is some flexibility. However, you don't have to specifically reference a specific person necessarily, but you do have to make sure that those contributions of those groups are set forth in your instructional materials somewhere at some grade level. So I think the answer is a soft no, but just, be careful really specifically excluding someone from a particular group if there's no other representation available in your instructional materials.
Okay. The next question I think we addressed in part when we spoke about books before, but just to be sure that we provided a clear answer, how does AB 1078 affect library books that may be inappropriate for certain age and grade levels?
I think this is one of the areas where, again, the lack of clarity or some of the ambiguity of the bill itself is going to create some challenges of implementation. Certainly, there's aspects within the authority of a school board to determine what is developmentally appropriate for its students. But again, depending on the nature of complaints that could be filed underneath the authority given under the bill, we could see some very varying outcomes in terms of how certain maybe perhaps the county office or district or even the state superintendent could intervene. So again, deferring back to what Kristen's original answer was, but it also comes down to how that interacts with the FAIR Act and how those actions occur and how you're trying to be respectful and reflective of obviously the diverse array of populations that are covered by the FAIR Act. So the long and the short answer is it remains to be seen, and we're going to continue to monitor this both in terms of the legal aspect, but also the advocacy perspective. I do want to, if I could, Troy, I wanted to jump ahead because I've seen a number of questions in terms of, some questions, maybe a little bit of frustration with the bill, kind of how to become more active. I would just, kind of, if I could lump those questions together, what I would say is I would strongly encourage all of you to become much more active in your advocacy. Here in CSBA's government relations, we are actively seeking out school board members to assist in our advocacy, both in the state legislature as well as the federal level. We embark upon a number of large advocacy efforts during the legislative year. And so you do receive a number of emails throughout the year soliciting and recruiting folks to become active. So we just want to encourage you, for those of you who are seeing this for the first time, perhaps, to use that as a catalyst for action in working with CSBA government relations and our advocacy.
Thank you for pointing that out, Chris. The next question, I think, it aligns with the last one, but again, we just want to be sure that we're addressing all the little nuances. So at the risk of redundancy, we're going to try and get to every question that we can within the allotted time. Can you discuss the way that this might impact school libraries? I think many people think of library books as instructional materials, but I'm not sure that's accurate. Any insights?
Yeah, so this has become a common question that we've been getting throughout the year. The bill has an expansive definition of instructional materials that basically encapsulates all materials that are both in the classroom, micro libraries, and that are in school classrooms as well as school libraries. So it does capture school libraries. And again, the issue of implementation of the bill will come into question, especially as it relates to these types of materials, because it's going to be unclear exactly how and when either the county or perhaps the state superintendent will get involved. So it's a lot of remains to be seen. But again, deferring back to one of Kristen's original answers, it also comes down to the ability of the district to determine what was the action or reflection of of eliminating access to materials that would otherwise be considered diverse or inclusive in alignment with the FAIR Act.
Carlos?
Yeah, and Chris touched upon the point that I wanted to make is that so the library resources are in that same category in terms of the standard that's applied to textbooks, instructional materials, and curriculum. In that, it's a determination of the basis that it include a study of the role and contributions of any individual or group consistent with requirements in existing law around including groups and individuals that represent the diversity of California. So that's a standard by which 1078 is measuring or what standard it's going to apply to governing boards in respect to its actions relating to library books and other instructional materials.
So another question about proportional representation, but we've spoken primarily in the context of English and social studies. They're asking, how does proportional representation apply to other subjects, math, science, as well as history, ELA? They mentioned CTE as well.
With the FAIR Act being relatively young in the statute, if you will, having been adopted a little over 10 years ago, provided a lot of discretion to school districts. This bill is going to kind of elevate some of the accountability measures, within and circulating around the FAIR Act. And so, unfortunately, my answer is going to be, it remains to be seen. How this is going to be enforced and how that's going to apply is going to come down to hopefully additional guidance that might come from the Department of Education, but also in terms of what we'll see at the ground level in districts as it relates.
If a school district picks Book A for social studies instead of Book B and a citizen complains, can the state superintendent of public instruction decide on their own that the district must go with Book B, even if the district gave no indication that they chose Book A for discriminatory reasons?
So this is one of the areas underneath the direct intervention that is of a concern. And it's going to be difficult to predict exactly what the state superintendent might do in response to a complaint filed directly with his or her office. But the short answer is yes, basically on how the language is written, the superintendent could choose the material. It would have to be standards aligned, FAIR Act aligned, certainly within the constructs of the statute, but that seems to be the intent of the law, that it would require, that allows the superintendent to choose the book and then bill the district for the cost of purchasing the book instructional materials for that district.
Is there case law or some type of clarity regarding the determination of whether some material meets or does not meet FAIR Act requirements?
I'm going to ask Kristen if she's there to come back on.
No, the short answer is no. And in a lot of ways, that for a long time was a good thing. We didn't want strict and hard rules about how to implement the FAIR Act, and CDE's own frequently asked questions about the FAIR Act says that there's flexibility and it's up to local control to decide how to implement it, and in what way. It just has to be done, but it is left to local control. So it's a good thing that we didn't have courts coming in and saying, here's how you have to do it. But that means that now we don't have answers about what the state superintendent is going to decide on these questions. So it's a little bit of a factor of the FAIR Act being left open, which was a good thing for local control, and now us being pushed in a different direction. So I wish I had better answers, but it is somewhat going to be in the discretion of whoever is the county superintendent or the state superintendent at the time, unfortunately.
One newly elected school board member for a high school district wants to know what advice you would give on how to navigate this new law.
That's a big question. I think it's just to be clear here. This is really to help provide additional information about what the law says and how the law and where we see some of the implementation challenges. I certainly would encourage, and we, it has been a long-standing policy of CSBA that districts, certainly have up-to-date instructional materials that their standards align and so forth. So, as a new school board member, I would encourage you to meet with your district staff and look at your existing instructional materials and to do an assessment as to whether they are or not, or could be considered to be standards aligned or not, or Fair Act aligned or not.
The next question says that they feel like this law opens the door for out-of-district advocacy groups to comb through all the districts to file complaints. Does a complaint have to come from someone within the particular district? I assume they mean a direct stakeholder, or could it be filed by somebody outside who is not a student, a staff member, a board member?
I mean, I'll say one thing real fast, and then I'll turn it over to Kristen. This is where we think there's a lack of clarity in the law as it's proposed. There are some provisions in the statutes as it's proposed in 1078 that create new statutes, and so they state, it states notwithstanding any other law, which basically disregards existing regulations or standards upon which complaints can be filed. So we'll see what, if any, actions come from the Department of Education to do regulations to further implement the law and provide greater guardrails. But that is one area of concern that we raised throughout in our advocacy on the bill.
Okay.
And the answer under current Williams statute and complaint and the current uniform or regulations and current uniform complaint regulations is that anyone can file a complaint, pretty much. So under Williams, it is anyone, and even complaints can be filed anonymously. So there you go. Under uniform complaints, it has to be related to it has to be filed by a student or an employee or a representative of one of them. It's a little less broad, but I think that the answer to your question is yes. Unfortunately, any kind of advocacy group is going to be able to initiate one of these complaints, even if there's been no intent to violate the Fair Act or any part of 1078, unfortunately.
Thank you for all your questions are coming in as fast or actually a little bit more quickly than we can answer them. So I'm going to get a little bit more selective to try and hit on different topic areas instead of revisiting nuances of questions that have already been asked and answered to some extent. The next question is whether the SSPI, the State Superintendent of Public Instruction, has enough staff to police this new law. And then the follow-up question is, could this possibly go all the way up to the Supreme Court if challenged?
I mean, I'll answer the first question, and I don't want to speak for the state superintendent. I don't think we want to speak for the Department of Education. That certainly would have to be an assessment that be done by the department as it relates to the development of the budget, the state budget, and if they ask for additional staff. So I think the answer is we don't know, and that we will see whether or not the state superintendent or the Department of Education requests additional funding in the state budget to address the implementation of the law.
And as to the Supreme Court, I assume the question means the United States Supreme Court. So they have jurisdiction to the extent that this statute would violate a federal statute or the federal Constitution. If so, I'm not aware at this point of this constitutional right of local boards to have control over their curriculum in this way. Certainly something that we're looking at, but that doesn't mean it can't get there. So, it just kind of depends somewhat on the political environment. And certainly there could also be a state level claim, and that would also, because it's the legislature making a statute, there'd have to likely be some violation of the state constitution for a state court claim. So that's kind of what we're looking at. So could it make it to the United States Supreme Court? Yes, it could. Anything is possible. I'm not sure what the grounds would be for at this point.
The next question is a hypothetical. On a Williams visitation, the county superintendent determines there is sufficiency of textbook. A subsequent UCP uniform complaint is filed with the SSPI. What are the next steps, or how would that be resolved?
So this is one area where we were again advocating some great concern in relation to the bill. The overlap between the complaints process was of a great concern for us. It is unclear exactly what complaint would hold precedent, or what could occur if the remedies proposed by either, let's say, a county office of education or the state superintendent are in conflict with each other. Which one then takes precedent? These are areas where we had great concern, and one of the reasons why we remained opposed to the bill. So the quick answer is, unfortunately, we don't know yet. We're hopeful that we will see further guidance or clarity coming from the state superintendent, but and again, also speaks to the matter of whether or not we will see follow-up legislation to provide a little bit of cleanup, if you will, in terms of how the bill will be implemented.
Josh?
Yeah, thank you, Troy. Just one thing to add, and when the sample policies are released next month, you'll see this. So while it's not required by law, there is some language in there, and it's contextualized with notes and things like that. So it's something that we want to consider. But there is language that will be in there that says, if you become aware of a sufficiency complaint filed with the SPI, that you do not need to wait for somehow the SPI to do something. In fact, as a board member, you could certainly ask staff what they're doing, and certainly if there is sufficient evidence to suggest that there is an issue, expectation would be that the district would do something about it. Now, that wouldn't preclude the SPI from doing something else, or not liking what you did, but there is, as board members, you do want to give some thought to, if there is that direct complaint, but for whatever reason the district is aware about it, what would you expect your staff to do? And maybe it's nothing, depending upon the, what's in the complaint, and maybe there's not enough to think that there's something there, but if there is, what would you expect to do?
Thank you. The next question asks, if the board action is a trigger, does the bill authorize the state superintendent of public instruction or the COE to intervene if the adoption is never placed on a board agenda, assuming the materials are not otherwise outdated?
So I was just thinking about trying to type an answer to that question. The way the bill is written, it could be a circumstance where the board did not act, right? Or if the board had, material that is, getting old or what have you, and has chosen not to act. That is unclear whether or not this bill captures those particular types of actions, for lack thereof, right? And so there remains, I think, some lack of clarity as to whether it is proactive actions by the board, or just boards who have, for no fault of their own, right, recognizing that some districts face fiscal constraints or other types of logistical challenges, are unable to adopt updated or more newer instructional materials.
As always, we have a question about basic aid. I assume this pertains to the penalty portion of noncompliance. If anyone could address that.
If we're going to make the presumption that that's the case, then, and speaking to what one of the previous questions that we got that Carlos and Kristen answered, is that yes, it would apply to basic aids, and it would come out of a future apportionment of some form, predominantly through the LCFF, their LCFF apportionment.
Great, thank you. Can discriminatory practices in the now approved CDE instructional materials now include religious groups too, since it is in opposition to their views in the estimation of this viewer?
I unfortunately don't really understand the question, but religion is.
I'll reframe it. I think what they're asking is whether religious groups could be considered a group that is being discriminated against and should be represented in the instructional materials that are approved by the board. So I guess that goes back to the definition of the FAIR Act and which groups are identified there for representation.
Yeah, so I would go back to what Josh said, and the general anti-discrimination provisions in the education code do include religion. So there's not, CDE wouldn't be able to discriminate against religious beliefs in anything that they did, nor could a district or the county superintendent. The FAIR Act doesn't specifically address religion, I think, because the idea was to get in groups that had not traditionally been represented, but it doesn't matter because you couldn't, and I apologize for my calendar update, you couldn't discriminate against religion anyway under the general anti-discrimination provisions of the education code.
And I also, in response to that question in the Q&A, I posted the Department of Education's FAQ on the bill that established the FAIR Act. That's also going to be served as a resource.
Yeah, it's really helpful.
Okay. Thank you for that. Does this apply in the same way to charter schools that don't use the State Board of Education adopted materials?
Yeah, so we had a pretty robust discussion about what applies to charter schools. The anti-discrimination and uniform complaint provisions do specifically apply to charter schools in the Act, but Williams complaints in general do not apply to charter schools, and they do indeed have some flexibility around state standards and things like that. That's kind of what the basis for our charter school is that they have flexibility to do things differently than public schools. So yes, as to the uniform complaint piece, they do have some obligations, but as to the rest of it, and I believe the fiscal penalties, and Chris, correct me if I'm wrong, only apply to school districts as well.
That is our read, yes. It remains to be seen in terms of the statute and how we're going to obviously see potentially either the State Department of Education interpreting the statute or providing guidance or an FAQ. But for at the time being, the discussion that we had was in this particular case, it depends on what part of the statute, but that's exactly right.
One viewer says that in their district, parents can flag library books that they do not want their students to check out. Would enforcing that policy be against AB 1078?
I don't believe so. This is about board action, not parents have quite the parents have quite a bit of authority through the parents. There's actually a parents' rights statute in the code. I believe it's 51101 of the education code for anybody who wants to nerd out with me. But there are existing rights for parents in that regard.
Yeah, I think the distinction is a board just completely removing something that maybe would violate some of the prohibitions in 1078 versus a single parent not wanting their particular student to read it, but other students would still have it available.
Got it. The next question asks whether the new. Okay. Oh, sorry. Go ahead, Josh.
Sure. Just I wanted to just distinguish one thing. So I think the question was about library books. But right. There is quite a bit out there about the content, instructional content standards, and that is not so easily exempted. There are only very few things that parents or guardians can exempt their children from, and it cannot be on the basis of any sort of discriminatory intent. So I just wanted to clarify that might apply to a particular library book, although even that is not so clear-cut, but that with respect to instructional content and the content standards, that is something that all students across California are expected to be taught and to learn, and there's no general exemption provision.
Okay. Does the new law change the timeline for responding to Williams complaints, and will it affect notice of complaint rights that must be posted in each classroom?
I don't think so. This is one of the areas that is really unclear because the statute doesn't specifically indicate that the state superintendent has to follow the Williams complaint regulations, but presumably they would have to follow the education code that sets forth those. So without further information, I would expect them to follow those. And if a district gets a direct filed Williams complaint, they should just treat it the same way they always have. Nothing changes as far as that if they file with you versus the state superintendent.
And I'll just say, again, this was a major component of our advocacy in the state legislature. The amendments to the bill, specifically amendments to adding new subdivision D of 35186, really does raise questions as to what kind of guardrails and processes the state superintendent or therefore the Department of Education will follow in terms of timelines, because it actually has some fairly declarative language saying exempting it from other parts of the statute that govern Williams.
So returning to the question about religious groups, someone offered a different interpretation of the original question. And in their view, the person was asking whether or not a religious group's views could be protected as a means to oppose materials that contain ideas of which they don't approve. For instance, could a religious group say that their rights are being violated if an LGBTQ representation is in a library or instructional material?
So I think the answer is no, not now under this statute. The statute just blanket says, and the FAIR Act just blanket says, you can't prohibit this and you have to have X representation in your curriculum and instructional materials. So there's no exemption for any particular group to not have to follow the FAIR Act or 1078. Now, could somebody bring some kind of lawsuit about that and have a court order that they have an exemption? Maybe. But right now, there's no exemption for anyone to not follow these requirements based on their particular protected class or belief system.
So we have a reference to case law. So Kristen and Josh, I'll be looking to you on this one. But apparently there was a decision, Board of Education, Island Trees Union Free District number 26 versus PICO from 1982. I'm sure you're familiar with that off the top of your head. But it leaves districts able to exclude books based on age appropriateness, and it would not be considered denying access. That's their interpretation of the decision. Could this be taken into account when removing books if a district does? And how does a district express that is why if they don't receive the complaint directly?
Can you repeat that last part for me, Troy?
So I think what they're asking is how can a board explain what their rationale was for excluding a book? If they were excluding it on the basis of this judicial decision that they cite, how would they be able to represent that and defend their decision if the district does not receive the complaint directly? It's instead routed to the state superintendent or the county.
Josh, did you have something? I saw you came on camera.
I was going to go after you took the hard question.
Yeah, I mean, part of the problem of this bill is that there isn't, the county superintendent, there is an ability for the district to remedy the issue. And in that step, I think you could explain, this is not about the FAIR Act. This is not about us excluding marginalized groups from our instructional materials. This is about profanity or age appropriateness or something like that. With the state superintendent intervention, one of the things we identified is that we don't see that right to remedy or to try to address it before they act. Certainly, if you knew about the complaint, you could send a letter or have your legal counsel reach out or something like that. But I would hope that the state superintendent would be focused on places where it was actually the intent was to violate the FAIR Act, if that ever happens, versus districts that are just addressing age appropriateness. And resources might play into that as well. But Troy, just for your information, I think this is more a process question than about the PICO case, which we actually are writing about for a future or it's in some piece that we're writing, so look for that. But I think it's more about a process question about how do you assert your legal basis for doing things, and it's really not clear in the bill.
Thank you. We had a couple others. Yeah, Josh.
Sorry, Troy, you called me out, so I wanted to jump in. Now that Kristen took the hard part of the question, I think I would just offer. I know there's been a lot of tension, of course, on the bill itself, but I think it may be helpful to take a step back and just recognize the FAIR Act has been in existence for 10 years, and the anti-discrimination laws, provisions, et cetera, have existed for, much, much longer than that. Obviously not always perfect, but, an improvement over time. And so if there are decisions made about a particular book, whether to exclude or include, there can be allegations of discrimination regardless of whether there was a public discussion by the board about why you chose to do that, or whether it was made by a principal or a review committee. And so, as with any sort of allegation, the context is going to matter. Is it in a context where a lot of board members weighed in and sort of voiced their opinions? Was it done sort of at the administrative level where there's nothing in the public record to explain why that occurred? But I would say that if the focus is on there's something sexually explicit and it was found in a grade that was too young, and that was sort of the basis for the complaint, and it was that pretty straightforward conversation, it may not trigger the general anti-discrimination provisions, period. In which case, I don't even know you need to get into sort of the 1078, sort of pieces or the details. So I'm not sure if that is helpful for the person who asked the question, but I think that in terms of what to take away as a board member, to think more broadly about the non-discrimination sort of framework, as how districts behave. I'll offer that as well.
Great. Thank you. The next question goes to discretion and the burden this places or would potentially place on school districts. It says that discretion is exactly where districts are going to get caught with complaints. Some materials used by teachers are far left or far right, already resulting in complaints against the district. Will the district be able to bill back the state for the amount of personnel time spent on complaint resolution?
There's nothing that we saw in the bill address that issue. Sorry, it's a very short answer. The bill did not provide any type of recompense or ability to draw back funding for the amount of time that districts will spend adjudicating or handling complaints.
Okay. We're getting toward the end, but I think we can get to all the questions, which is quite an accomplishment. Does this legislation then override a parent's choice to not allow their child access to certain books? Example, a first grader wishes to check out a book about a transgender girl. In checkout process, there is a flag because the parent has asked for this topic not to be an allowable topic for their first grade.
Right. So I'll defer to we had a very similar previous question on this, and I saw that this person who asked the question lost some connectivity earlier. The quick answer is no. The parents' rights remain. This bill deals directly with board action. So there are rights that are afforded within the education code that allow parents to continue to do that and will continue to be observed.
And then someone is comparing this bill to be censorship in effect. How would you respond to that?
I'm sorry, I missed that last part.
For those who regard this bill as a form of censorship, how would you respond to that?
I will just say this: the intent of the legislation was to address issues of censorship. That was the stated intent by the author and the governor and the development of the language. And so I can only speak to what the intent of the legislation was in that regard. In terms of its impacts, however, we do have concerns that this could be used for other purposes. But again, that remains to be seen. This will come, and I think this kind of speaks to the issues of the next question about ambiguities and what the timeline might be. In that regard, we're going to continue to monitor how this law is implemented, whether or not the Department of Education issues additional FAQ or guidance on it, and of course, whether or not there's going to be a need for additional cleanup legislation. We will be at the forefront of those conversations.
A couple questions came in about the costs associated with this potentially being a mandated cost issue. How would you respond to that?
Certainly, the bill does have what's called the mandates clause in it. This is standard procedure for legislation that could institute new costs upon districts. This makes it a claimable mandate to the State Mandates Commission. Of course, that doesn't always reflect the adequate or the true nature of the costs of any kind of legislation, notwithstanding this legislation, but others, of course. And so we certainly will be monitoring what the true costs are, because this will be something that will have downstream implications for districts' operational funds.
And then we have a question about this bill's relationship to the California Constitution. Does it violate the Constitution, and does it undermine local control in an unacceptable way? Those are sort of two separate questions. First, address the constitutionality piece, and then the local control part.
I mean, if I could flip it around a little bit, just in terms of I think you've heard this throughout the webinar, our concerns that this really does interfered and obstructed with local control. That has been one of the major thrusts of our advocacy, and one of the reasons why CSBA remain in opposition to the bill, because it's the local districts and local school boards that know best what their communities need, and that was one of our major concerns and why we remained opposed to the bill.
And with that, let's return to a point that you made earlier, Chris. There have been a number of questions which addressed in some form what, if any, further steps will CSBA take to push back against this or to defend local control?
Okay. Local control and preserving local control and the authority of school boards is our ethos. We will continue to fight for the rights and authorities of our elected school board members in the legislature. That is paramount in our advocacy. Please stay tuned. We will continue to provide updates on this bill as well as many others. I will just say that the governor still has another 2 weeks to be able to sign legislation that is on his desk. And so we will be providing regular updates. I know many of you get a lot of emails from us, but we do send out a weekly update on Wednesday afternoons that includes a legislative update as well as many other important pieces of information. Encourage you to please pay attention to that, because those will have opportunities for advocacy and as well as information about what's happening here in Sacramento.
And then we have a question wondering if we have a list of how everyone voted. This is a great opportunity to plug CSBA publications. In the winter edition of our California Schools magazine, which all members should receive, we have a list of the most important bills impacting public schools. We do this every year. We have a list of how all legislators in the Assembly and the Senate voted on key bills. It's a scorecard that you can use to evaluate whether they're supporting public schools as they should be supported in your view. So absolutely, we will provide an accounting of how people cast a vote on AB 1078. So we're into stoppage time. So if there are no further questions, we will adjourn for today. Thanks to our panelists and also to everyone who participated. Please continue to read CSBA communications. We will update on you on this issue and provide further resources as we gain more clarity. Thank you and good day.